Most people think that if their loved one had a will, probate is taken care of, that the will handles everything. That's actually one of the most common misconceptions families bring into this process. Having a will does not skip probate in Florida. It guides it. In this video, I'm going to explain exactly what probate is, why it exists, and what actually means for your family when someone passes away. If you are watching this because someone you love just passed away, and you've suddenly found yourself responsible for their estate, this video is for you. Whether you've been named a personal representative or you're an heir trying to figure out what comes next, or you just heard the word probate for the first time and started researching, you are in the right place. Most people have never been through this before. So if it feels confusing and overwhelming right now, it's completely normal. So, what is probate? At its core, probate is a court-supervised legal process. It has 4 main jobs. First, if the person left a will, the court verifies that the will is valid, that it was properly signed, properly witnessed, and that it actually represents the person's final wishes. Second, the court appoints someone to manage the estate. In Florida, that person is called the personal representative. The personal representative has the legal authority to act on behalf of the estate throughout the entire process. In most other states, that same role is called an executor or an administrator. In Florida, it's personal representative. You'll hear that term throughout this video and across this YouTube channel. Third, the estate's obligations are addressed. Creditors must be notified and given a legal window of time to file claims. During this stage, the personal representative works with the attorney to handle things like paying valid debts, addressing taxes, and managing the estate's financial responsibilities. Fourth, once those obligations are resolved, the remaining assets are transferred to the rightful heirs or beneficiaries. That's really what probate is, a structured legal handoff of a person's assets after they pass away. In Florida, probate is governed by the Florida Probate Code. That's chapters 731 through 735 of the Florida statutes. It's a well-defined process with clear rules and predictable steps. Now, there's one part of this process that surprises almost every family. I'll get to that in a few minutes. If you find explanations like this helpful, consider subscribing to this channel. I make videos explaining how probate works in Florida and what families can expect along the way. By the way, my name is Michelle Miller. I'm a real estate agent in Lee County, Florida, and I hold a certified probate expert designation. Through my work, I often help families navigate probate when real estate is involved. Here on this channel, I break down how the process works so families can better understand what to expect. So if a will doesn't automatically trigger probate, what does? Here's the key principle to understand. Probate is triggered when assets are owned in a way that has no automatic legal transfer at death. Let me say that again, because it's important. Probate is triggered when there is no automatic legal transfer. Think about it this way. Some assets are set up so that when a person passes away, ownership transfers automatically without any court involvement at all. That might be assets held inside a revocable living trust, which are distributed according to the trust terms rather than through probate. Accounts with named beneficiaries, such as bank accounts or investment accounts that have payable on death, that's POD, or transfer on death, TOD, designations. Life insurance policies that name a beneficiary. Retirement accounts such as IRAs or 401ks with designated beneficiaries. Property owned jointly with right of survivorship, where ownership automatically passes to the surviving owner. Ladybird deed, that's enhanced life estate deed, which allows real estate to transfer directly to a named beneficiary when the owner passes away. Those assets move on their own. But what about a house that was titled only in the deceased person's name? No joint owner, no beneficiary, just their name on the deed. Let's say that home is in Cape Coral. When that person passes away, nothing happens automatically. The title doesn't move, the property cannot be sold, it cannot be transferred. It just sits there, legally frozen. That happens because the property was titled only in that person's name, and none of the probate avoidance tools were in place, such as joint ownership with right of survivorship, a revocable living trust, a ladybird deed, or another legal transfer arrangement. Without one of those structures in place, the court has to step in to legally move the title from the deceased person to the heirs. And that court process is called probate. The same idea applies to other assets too. If something is owned only in the person's name with no beneficiary or trust attached, it usually has to go through probate. When you first heard the word probate, did you already know what it meant? Or did you have to start researching everything from scratch? Let me know in the comments. I read everyone. Now, not all probate in Florida is the same. Florida law actually provides 3 different pathways, depending on the situation. The first is called formal administration. This is the full probate process, and it's what most families are dealing with. It's required when non-exempt probate assets exceed $75,000 or when the person passed away within the last 2 years. Formal administration involves appointing a personal representative, going through a creditor notice period, inventory the estate's assets, paying valid debts, filing final income tax returns, and distributing what remains to the heirs. In Lee County, formal administration is handled through the 20th Judicial Circuit Court, right here in Fort Myers. The second path is called summary administration. Summary administration is a simplified, faster option. It's available when the total value of the non-exempt probate asset is $75,000 or less, or when the person passed away more than 2 years ago. In summary administration, the court does not appoint a personal representative the way it does in formal administration. Instead, a petition is filed, in most cases by a Florida probate attorney, asking the court to order distribution of assets directly to the beneficiaries. There are no letters of administration issued. No one carries the formal fiduciary title of a personal representative. It's less complex and less expensive than formal administration. The third pathway is one that's especially relevant here in Lee County. It's called ancillary administration. Ancillary administration applies when a person lived and passed away in another state, but owned the real property or assets here in Florida. Because Florida courts have to oversee the transfer of Florida property, a separate Florida probate proceeding has to be opened, even if a full probate is already underway in the person's home state. This comes up a lot here in Lee County. We have a significant snowbird population. Families from the Northeast, the Midwest, Canada, who owns a condo or a home here in Cape Coral or Fort Myers, but their primary residence is somewhere else. When that person passes away, their home state handles most of the estate, but Florida property requires its own Florida process. That's what ancillary administration is for. Now, I mentioned earlier that there is one part of this process that surprises almost every family. Here it is. Even after all the paperwork is filed, even after personal representative is officially appointed, no assets can be distributed to heirs yet. Florida law requires what's called a creditor claims period, a required window of time, 3 months from the date a notice to creditors published, during which any creditors can come forward and file claims against the estate. Think about that. 3 months where the estate is essentially on hold, waiting to see if anyone is owed money. It's not all paperwork. A significant portion of the probate process is simply waiting for the creditor period to close, and then reviewing and paying any valid claims before anything goes to the beneficiaries. After that period closes, the personal representative begins wrapping up the estate by paying valid debts and the expenses of the estate, filing any required final tax returns, preparing a final accounting if one is required, and then distributing the remaining assets to the heirs according to the will or Florida law. That's the full arc of probate, from filing to close. Before I wrap up, I want to touch on something that is specific to Florida, and that trips up a lot of families in the probate process. It's called homestead. In Florida, if the deceased person's primary residence was in this state, that property may qualify as a Florida homestead. Homestead protection in Florida is significant. It means the home is generally shielded from most creditor claims during probate. Even if the estate has outstanding debts, the primary residence may be protected. But here's where it gets important, and where families sometimes make costly mistakes. Homestead doesn't just protect the property from creditors, it also creates specific rules about how that property can be inherited. And those rules depending entirely on who survived the deceased. If a spouse and the children both survived, The surviving spouse doesn't automatically own the home outright. Florida law may give the spouse a life estate, with the children holding a vested remainder interest. The spouse does have options, but those options have deadlines. Florida law gives the surviving spouse a limited window to make that election. So it's important to discuss those choices with a probate attorney early in the process. If the deceased was survived by minor children and no spouse, the homestead generally cannot be devised at all, regardless of what the will says. This is one area where I always encourage families to work closely with a licensed Florida probate attorney. Mishandling homestead classification can have serious legal and financial consequences. Getting it right protects the family. If you're not sure where to start, I've put together a free probate navigation checklist that walks you through the first steps: what to gather, who to call, and what comes next. The link is in the description below. So the key thing to understand is this: probate is not a punishment. It's not a sign that something went wrong. It's simply the legal process Florida uses to make sure that a person's assets are transferred correctly, that the will is verified if there is one, that debts are properly handled, and that the right people receive what they are supposed to receive. It's structured, it's predictable, and it becomes much more manageable once you understand what's actually required. You don't have to figure this out alone. That's exactly why this resource exists. This video is for educational purposes only and is not legal advice. For guidance specific to your estate, always consult a licensed Florida probate attorney. Now that you understand what probate actually is in Florida, the next question many families start asking is about the house. When someone passes away and the home becomes part of the estate, people often wonder, when can a probate property actually be sold in Florida? Do you have to wait until probate is finished? Or can the house be sold during the probate process? And who even has the authority to sell it in the first place? That's exactly what we'll walk through in the next video.